All right. Hi, everybody. This is Z coming to you from Awanna Holdings and NoVa Notes. And today we are going to talk with the Griffin Firm. And I have Ms. Kristen Wilson and Ms. Shakisha Morgan with us today to talk to us about estate planning. So you all know the drill. Let me go back up here. And we're going to go through our disclaimer first. And of course, as usual, this is not an offer or an invitation for any financial products or anything like that. I'm not a lawyer. I don't play one on TV. I'm not a tax professional or anything like that. So seek those professionals out for that advice. But actually, our guests today are attorneys. So they are qualified to answer any of those questions that you might have. So, so let's go into a little bit about myself. Again, my name is Awanna. Everybody affectionately calls me Z. I am a retired Navy veteran and current DoD contracting officer. Have a bachelor's in education and a master's in education, as well as a master's in public administration. Been real estate investing for a little over 30 years, but only started my business with Awanna Holdings in 2018, where I decided to go into mortgage note investing. And I'm going to go through this fairly quickly because I go through this at the beginning of all of my videos. So you guys can catch it there or rewind it to catch it. Here's how you can get in touch with me. I'm all over on Facebook, Instagram, LinkedIn, Meetup, YouTube, and my website. Okay, so let's talk a little bit about what a note is for those of you that are new and may not understand what a note is. To put it simply, if you are a person who has a mortgage from a bank, that means that you've taken out a lien on that home and a loan with the bank. That loan is what mortgage note investors purchase, and we purchase those mortgage notes at a discount, typically from a discount based on the balance on your mortgage. So it's a little bit different from people who are in real estate investing who might do fix and flips, where they actually own the property, whereas mortgage note investors own the lien on the property. Okay, so just wanted to make that clear about the difference between mortgage note investing and actually real estate investing where you own the property. So let's go a little bit into our guests today. I'm so excited to have them. And so Ms. Shakisha Morgan and Ms. Kristen Wilson from the Griffin Firm are here to talk to us about estate planning. And estate planning is a huge thing. It's going to be a huge thing. It's going to mean a lot to us in the African American community, because a lot of us don't plan for that. So we know that GoFundMe is not an estate plan. Okay, so I'm gonna turn it over to the experts and let them go through and explain what we're supposed to be doing for estate planning. So take it away, ladies. I'm gonna take down this share screen, so in the event that you guys want to share something, you can do that, and then we can see each other. So take some off you and
thank you for having us, Z. You know, one of the things that you mentioned at the beginning was a little bit of a disclaimer. So yes, while we are lawyers and we can provide information in this field, I'm going to do a little disclaimer for us as well, because it's important that people understand that this is educational information. So we're sharing with you some of the general strategies, general principles, not just around estate planning, but also business planning. And we just want to make sure that you understand that this doesn't create an attorney-client relationship between us. But if you are interested in that, please feel free to contact us. We will provide our contact information. But it's just important for you to know that we are sharing this information because, similar to Z, we are all about educating the community. And so we know that people take action based on understanding. And so when we share what we understand, what we know about the law, what we know about the principles related to estate and business planning, we are empowering other people to act. So I am excited to be here to represent the Griffin Firm with Kristen Wilson. We are going to be talking about creating a legacy, not just through estate planning, but also through business planning, because we want to make sure that those who are here understand that there is both a personal and a business side to planning. Wise people plan ahead. And if you are here, you have certainly sought this wisdom. And so we want to give that to you. So let me start by introducing our firm.
Definitely have some questions for you on the business planning front, because a lot of my listeners and followers are business owners. So
yes, that's what we understand. So we want to make sure we talk to everybody where they are. And so we wanted to start by introducing our firm. We work for the Griffin Firm. We are an estate planning, business succession planning, and probate firm located in the DMV. We serve clients in DC, Maryland, Virginia, and Massachusetts. We are excited because we are a growing team of Black women serving the community, educating the community, and doing it with excellence. And so we are excited to be here to represent the team, the machine that is behind us. And the two of us that are here to speak today is myself, Shakisha Morgan, and Kristen Wilson. I'll let her introduce herself in a little bit. I'll tell you a little bit about me. I am an estate planning and probate attorney with the Griffin Firm. I work with individuals, with families to help plan their legacy using various estate planning strategies. But I also help for those who are in a situation where proper planning may not have occurred. And so a loved one's affairs pass through what we call the probate process. And so I help to facilitate peace even through that probate process for those who have not done extensive planning, and making sure that to implement strategies to still be able to try to retain some wealth as it goes from generation to generation. And so I love the work that I do with the Griffin Firm, and I love to work with Kristen J. Wilson, who is going to introduce herself.
I love to work with you too, Shakisha. This is Kristen Wilson. I am, like Shakisha, an estate planning attorney. I also have a focus in tax planning, and really what that comes down to is once you have created your wealth, you want to preserve it and keep as much of it in your legacy and keep it from going to the IRS. And so that's what I like to help people focus on. And I love working at the Griffin Firm. So I'll let Shakisha talk about estate planning on the personal side.
Kristen, if you get a second, turn your mic up some. I want to make sure that we are able to hear everything that you guys are talking to us about.
Awesome. Thank you, Z. All right. So I want to start with the Griffin Firm's guiding principle, because we work off of 5 pillars. And the first pillar is faith. So one of the things, though, that we like to really let people know is whether or not you are a person of faith, this scripture is applicable no matter what type of client you are, because we are lawyers. And so if you do not have a vision that you need to implement, that we're using estate planning and tax planning and business succession planning strategies around, you need to be able to make it plain. And most importantly, it needs to be written down. And it needs to be written down because writing it down makes it enforceable. Writing it down in the right way, I should say, makes it enforceable. And so we use this as a guiding principle, not just as people of faith, but specifically as attorneys, helping people to transfer their legacies from generation to generation. I want to start by talking about the personal side of estate planning, and I want everyone to understand that estate planning is designed to answer 3 major questions. The first major question is, what happens when I die? And it is the question that almost everybody has, because it is the one thing in this life that we know is guaranteed. It may not be guaranteed that a business might boom, but we hope it will. It might not be guaranteed that we may always have the capacity to manage our affairs, but we hope it will. But what happens when we die is the number one question that we get when people come and call us. The second question is, what happens if I don't die? And that really talks about, what if I'm alive, but in some way unable to manage the things that I am managing? This is going to be something that's relevant not only on the personal side, but also on the business side, which is why we talk about business succession planning. Because on a personal side, you're thinking about the personal things that you're managing, but also on a business side, especially if you are a business owner who is a person of color, a lot of what you're doing, you're starting that business to meet a need in the community. And so you don't want the goals of that business to be impeded because of an incapacity for yourself. And so you want to make sure that you're being strategic with your business planning as well. Most importantly, though, when people work with us, we want people to know that our focus is on legacy creation. And so you're not just going to come to us and spout some words at us and we'll just write it down. We are not transcribers. We are legacy makers. And so we will be working with people to use estate planning strategies, to use business succession strategies to create legacies. Now, in order to be able to do this, you have to start, what did I say? Action starts with understanding. So we start by thinking about what happens when I die. It's important that we note here that over 50% of US adults die without a will. That's terrible, because that means that over half of our adult population in this country, when they die, there is nothing that says what's supposed to happen next. So not only do you have loved ones who are grieving, but you have loved ones who are grieving and are confused. Loved ones who are grieving and have anxiety. Loved ones who are grieving and don't know what the next step is. Now, when we talk about people of color, specifically Black people in this country, 70% of us die without a will. And so that really impacts the ability to be able to pass on a legacy. So I want you all to know what happens when you die. When you die, everyone has what's called an estate, and the estate is everything that you own. That's it. It's a really easy way to say it. A lot of people think estate sale when they think of estate. So they're like, oh, estate means rich. Estate means what do I legally own at the time I pass? And when you have an estate, there's 3 ways that an estate can be taken care of, because there's always got to be a legal process. When someone dies, the question is, what legal process applies to their estate? If you do not have a will, the legal process that applies is probate. And probate is the legal process where someone's got to go to court. We don't know who that might be. It could be any member of your family, right? It could be someone who wants to help but is an extended member. Maybe you don't have family who can help, but someone's got to go to court, get appointed to represent your estate. It doesn't have to be a lawyer, but an individual to represent your estate. And the government is going to tell them what happens to your stuff. It is the least powerful position to be in, because you've done all these things in your lifetime to take care of yourself, to build wealth, but you've got no plan about what happens after. And so at the very least, everyone should have a will, because with a will, even though the court process of probate happens, a will helps to guide that process. It gets to decide who is the person that goes to court and represents my estate. That could be a friend, that could be a family member. It's whoever you know would be best positioned to do that. And then as the court process goes, handles itself, and the court oversees that process, at the end of the process, there is a point where distributions can be made. So your estate can be given to people or given to institutions. With a will, you get to decide who that is when that point in the process occurs. And so it's a very powerful position to be in, just to have a will. There's some people who need to have a will. If you have minor children, you need to have a will. If you have feuding family members, you need to have a will. If you are single and no kids, you need to have a will. I think I've covered everybody. If you're married, if you got kids, if you're male, if you're female, if you're anything in between, if you are over the age of 18, you should have a will. And so hopefully I've covered everybody. You've fallen in some category. Now, there are some people who have what's called a living trust. And a living trust is a type of estate planning tool where your estate now doesn't need to go through the court process in order for it to be given to those whom you want to inherit from you. Instead, if it is in that trust, and I'll talk about what that looks like in a little bit, then it avoids that court process in total, and you get to decide who gets your stuff. Now, for those of you, we're here with Z and we're talking about people who are real estate owners and real estate investors. Trusts are going to be a powerful tool for this group of people. You really want to think about how you can be strategic about the wealth you're creating through real estate and using trust and business succession planning to do that. All right. If you
us to wait till the end to ask any questions, or should
I think it's helpful to kind of hear all of what we'll say, because sometimes people's questions are answered in the presentation.
Okay, go ahead.
But if you think of a question and you want to put in the chat, feel free to go ahead and we'll hop on it after. All right.
Thank you.
The second question, remember I talked about those 3 questions. The second question is about what happens if I don't die. This is a major question that people aren't clear on because they think that if, you know, someone needs to step in and help me, they can just go to the court and ask. And that is a really oversimplified way of thinking about that process. The court process is not easy. And you have to think about, if I become incapacitated, how does my family or my loved ones quickly be able to step in and help me? If I don't have estate planning documents, then they're going to have to go to court. And if anybody has gone to court to deal with a traffic ticket, you know how painful that is. And that's just a traffic ticket. We're not even talking about something as sensitive and as time consuming as the process called guardianship. That is the legal process where someone, if you become incapacitated, has to go to court, ask the court to hold a hearing to declare you unable to manage your stuff, and then to declare them as the person who can manage it. It really takes a lot out of you. And when a family is grieving because a loved one is in this position, you don't want them having to be dragged through the court process in order to deal with that. So what then happens? What you do is, every single person who is listening to us, if there is nothing that you do after you leave here, find an estate planning attorney and get these 3 documents. They are the foundational documents of estate planning. Everyone should have them. Everyone at the age of 18, doesn't matter how much you have, I promise you, these documents make such a difference. First, with the durable power of attorney, you're empowering someone to literally stand in your place to deal with legal and financial affairs. This is extremely powerful, because if you can imagine being in a position where for some reason you can't take care of your stuff, someone you trust can immediately step in and be able to do that. With a healthcare packet includes what people are familiar with, the healthcare power of attorney, advance directive. We've got a couple of extra things in there because, you know, we just really like our clients. But what the point of this document is to make sure that if you become incapacitated, someone who loves you, someone you trust, can step in your place and make sure you get the proper medical care. Now, I'm just going to stick aside in this. We all know what's going on right now with COVID-19. We know what's happening in terms of our own community and the rates of COVID-19. And even before the pandemic happened, we know our community's relationship with medical care providers. Don't leave yourself without an advocate. Okay, I'm gonna just stop there. I'm gonna just let y'all sit in that because y'all already know what I'm talking about related to that. And then the last one is a last will and testament. Everyone should have a will. Remember that list that I just went over? Go ahead and rewind this tape and listen to it and see what category you fall in, and make sure you get a will, because it is what happens when you want to empower someone to manage your affairs after you pass. Everybody should have these 3 at the very least. If you come and you meet with us and you say, hey, I have no estate planning documents, know that we're going to tell you, you gotta have these 3 at the very outset, okay? Everybody should have these 3. And if you've got some real property, right? We're talking to people who are investing in real property. If you're someone who owns real property, then you wanna consider what we call a transfer on death deed. It's one of those things that makes sure that if you own property, you are transferring that property at death, because that is typically at the time when it is most appreciated in value. A lot of people will just take a little shortcut and just add people's names on their deeds, and that creates all sorts of issues with capital gains taxes and things that our community is just not aware of. And what we want you to do is we want you to know that that is not only is it not a shortcut, but it actually disadvantages your loved ones. What you want to do is you want to transfer any real property you own at the time of death, so that you make sure it's transferred at its highest value. All right, I'm going to stick a pin here, and I'm going to talk a little bit about trust, because there's so many myths around trust and people get nervous talking about trust. And my name is not Bill Gates, so why are we talking about trust? We're talking about trust because trusts are for strategic people. And if you're on this live, if you're watching this after, we know that you are strategic in the things that you do. I mean, most people don't just talk about mortgage notes just over the dinner table like that. You know, it's not really a happy hour conversation that you hear, you know, back when we used to go outside. So if you are someone who is strategic, you want to think about whether or not you want to use a trust. And I'm going to give you my 3-point consideration as to why you want to think about using a trust. Number 1 is privacy. If you don't want people in your business as to what you own, what the value is of what you own, who's getting what you own, when they're getting it, why they're getting it, you want to consider using a trust. Because since a trust passes outside of the court process called probate, then that means it's not public, it's private. And when it is private, then that means you have the security of knowing that what you've decided for your family gets to stay in your family. The second one is provision, because a lot of times when we think about wealth generation, when we think about passing on legacy, time matters, right? And so sometimes there are things we want to give people immediately at the time we pass, no delay. And then there's some things that we want to provide later on in the future. Maybe that's a grandparent providing for education for their grandchild. Maybe it is a loved one who understands that the person that they're leaving stuff to, and then maybe a little bit of a spendthrift, and so they need to measure out what they're leaving for that person. And so those are the things that you want to consider. And the last one is purpose, because there are some things that you want to do that you can only use a trust for. There's some people who are so strategic and they have these big ideas about how they want to pass legacy. Sometimes you have to use a trust to do it, because the court process is not always going to be considerate of all the various ways that you want to creatively provide for your family, for your loved ones, and for your community. And so if you're thinking about a trust, you want to think about these two big categories and what they're used for. One is a revocable living trust, and that type of trust is all about access and control. So during your lifetime, you get to have all access to everything that you put in the trust. You can use it as much as you want. You can use as much of it or as little of it as you want. And you get to change your mind about everything that you put in the trust over the course of your lifetime. An irrevocable living trust is about asset protection, and it requires a loss of control in order to get that asset protection. So it really is a different type of vehicle that when we're talking to people about the use of this type of trust, it really is thinking about it like a locked treasure chest box. Because since you want to protect what's inside, sometimes you even need to protect what's inside from your own self and from your desires to kind of spend down on it as well. So it really is a specific type of strategic tool that, for example, the things that you put in there would no longer be counted as personal property of yours. So if I put, money or anything in there, it's no longer counted as mine. So because it's no longer mine, that means my control of it shifts. So really you have to weigh the balance of what is it I'm trying to protect, and how much loss of control am I willing to, accept in order to protect that for those who use this type of trust. But a trust is just that. It's a tool. It's a tool to be used strategically by those who really want to think about leaving a legacy. So when we think about leaving a legacy, we love to tell the story of Osceola McCoy. She is our boss, Amy Griffin's favorite person. I feel like you could really put Osceola up against her kids. I don't know if you could put her up against the grandkids, but I definitely think Osceola, Amy's kids, kind of equal playing field right there. Osceola was a woman who left a legacy. And so if you don't know her, you should look her up, Osceola McCoy. She is the most famous benefactor of the University of Southern Mississippi. She wasn't someone who was rich. She was a washerwoman. But she was intentional about the way she used her money. She was frugal. She took care of her needs, but she thought about leaving a legacy. And because she was so good with her money, saving it, then she had a banking representative who really was like, you really should consider what you want to do with this when you die. So we can create a tool where you can get taken care of during your lifetime, and after you die, you get to decide who gets what that is. And so while she was living, the trust took care of her. And when she died, her trust was set aside for those who wanted to attend the University of Southern Mississippi and couldn't afford it. Talk about leaving a legacy, right? It's all about intention. And that's why you want to work with a professional who can help you to be strategic. Because when you're strategic, you never leave money without instructions. And you always begin with the end in mind. You always start with the goals. And then a good advisor talks about the path to get there. And so some of the things you want to think about are things like debt management, because just because you have debt doesn't mean you can't leave a legacy. You can still do it. You want to think about the structure of your family, those you love, those who depend upon you. You want to think about whether you want to avoid the court process, because for some people, it's going to cost way more for them to go through, for their estate to go through the probate process. You want to think about the fact that families feud. And, you know, it's hard because some people just think the best of their loved ones, but families feud and they turn into lawsuits. The last thing you want is you did all that work to create all that legacy while you were living. And then when you pass, your family wastes it because they're in court back and forth arguing over what should happen and who should get what and who should control it. Specifically, what we're going to talk about here is business and succession planning, and thinking about, if I have a business that I have started to serve the community, why would I want that business to die with me? Wouldn't I want that business to live beyond me and to continue serving the community? That's why. And then you want to think about charitable giving, because I know that people, especially African Americans, we are known to be the most charitable community. However, when we die, you don't see those numbers, because since we don't have estate plans, when you don't have an estate plan, your estate cannot give charitably. That's just how the law is set up. The law is not thinking about who your favorite charities were during your lifetime and feeling like, how can we weed this into their estate? If you don't have a will, you will not give charitably upon your passing. And so for someone like me who, you know, the schools I went to, they don't need my money. They are private institutions with large endowments. But when I think about the HBCUs and the impact that they have had on my community, my people, and just the upward mobility of Black people, those are the schools in my estate plan, because I want to make sure that I'm giving back. They won't know who I am, but hey, that's okay. I just want you to use the money well. All right, so I'm going to turn it over to Kristen, because that is the personal side of estate planning. I hope that wasn't too overwhelming for people, but I do hope that that motivated you to action. And so I'm going to let Kristen
That's why we record it, so they can go back and look at it.
Good. So I'm going to let Kristen take it away to talk about real estate investments.
All right.
Thank you, Shakisha. How is my microphone?
You're fine. You're fine.
Okay. All right. All right. So we're going to talk about real estate investment vehicles. So I know that this group is geared toward real estate investment and note investment. And we want to just be mindful and strategic about how we go about investing. I know a lot of people just invest as themselves, but I want you to know that there are other options, specifically creating a business from which to invest, or having your business be the one that invests. So there are many options, but in the interest of time, we'll go over three of the most common, or the ones that you'll see occurring the most often: the sole proprietorship, the limited partnership, or LP, and the limited liability company, or LLC, which you hear all the time. So first of all, choosing the right structure, the importance of choosing the right structure is that it's going to reduce your exposure to liability. Shakisha talked a little bit about lawsuits, and you know, we never want that to be us. We never really expect it to happen to us. But lawsuits can be devastating. Lawsuits can destroy the legacy that you've worked so hard to build, the money that you saved up, the businesses that you tried to create. And so we want to, as much as possible, reduce our exposure to liability from lawsuits, from legal liability, as much as we can, by choosing the appropriate structure for the business that we want to run. Second, minimize taxation. I told you I'm all about keeping as much as possible. I believe in rendering unto Caesar what is Caesar's, but I think that there is a strategic way to decide what belongs to Caesar, and it's built into the Internal Revenue Code, the laws that surround taxation. And when we know and understand those laws, then we can work with them to make sure that we keep as much as possible. Third, increasing access to capital. There are ways that you can invest that don't require you to use your own money. And that's wise, that's prudent, that's smart. But you have to have the right structure that's going to bring those investors to you so that you can then invest their money and keep some of the profits. And last, we're going to create an access point to new or modest investors. There are investors that are willing to take on more risk than others. But for some people that are new to investing, there are some business structures that might give them a little bit more comfort and limit their liability, their personal liability. And so we'll talk about those in just a second. primary considerations, these are the things that are really going to set each business entity or business structure apart from the rest. So we'll look at asset protection. Each business structure is going to protect your assets differently, some not at all. The tax incentives, there are some that are favorable depending on where you are, depending on how much money you're dealing with. There are different incentives as it pertains to tax. The cost of starting the business, there are some fees involved for some. And then formalities and requirements, we never want to disregard that. I know for myself, formalities and requirements are, something that I always have to make sure I'm calendaring very meticulously to make sure that I'm on time with a lot of those things. In the law, there's always a deadline for something. And so we want to make sure that we're paying attention to that as well. Okay. First, we have the sole proprietorship. So sole proprietorship basically means you're an individual entrepreneur. This is one owner, the business is owned and operated by one person, and there is no legal distinction between the owner and the business. You are the business is you. You can think about it as, in the summertime when I was growing up, we always had the one guy with the lawnmower who would just go door to door and say, hey, can I mow your lawn? 10 bucks, I'll rake your leaves or I'll shovel your snow. That's what you think of when you think of a sole proprietorship. He doesn't have, articles of organization or anything like that. He is just one person running a business. And so the benefit to that is the ease. So you could be, an 18-year-old kid and just start a business. You can start a lemonade stand. You can sell water on the corner. It's really easy to start that business. All you have to do is jump into action. Additionally, there's no cost of formation. You just do it. One of the disadvantages, though, is the liability exposure. So if something were to happen with that lawnmower and a lawsuit ensued, that individual would be personally liable for whatever damages that there were. In addition, all of the funding comes from your personal finances. So to get started, you have to buy gas for the lawnmower. You don't necessarily have an investor. That's coming out of your own pocket. And there's also the lack of privacy. We talked about the importance of privacy. Sometimes you don't want people to know what you own, what your business owns. Specifically as it pertains to real estate, if you own a home or you invest in real estate, when someone goes to land records to see who owns this home or who owns this note, they will see your name as a sole proprietor. And for some people, that's okay. And for some people, you want more privacy. And so if you do want more privacy, you might want to look at the limited partnership or the limited liability company. Okay, so we have the limited partnership where we have at minimum 2 partners. We have a general partner and a limited partner. The general partner kind of operates like a sole proprietor in the sense that that person will have complete control of the operation. However, they will also have that unlimited liability, so they have more exposure. The limited partner is kind of the person that works in the background. They are backing the business, they have less control, but they enjoy limited liability. So they are only liable to the extent that they have contributed financially to the partnership. So if I'm the limited partner and I have contributed $1,000 to this business, if the business is sued, I'm only liable up until $1,000. You can't reach into my bank account and take, 1,005 from my checking account. So that's a benefit for the limited partner. And again, when we talk about people's risk tolerance, some people would want to serve as a general partner because they want the control. They're okay with the risk. And in that case, you find someone who wants to serve as a limited partner, you come together and form a partnership. One thing I do want to point out is taxation. There is pass-through taxation for a limited partnership. And what that means is that all of the income and the deductions, the credits, all of the things that you typically will report on your income tax return passes through the business to the owners, to the individual owners. So even the losses will pass through to the owners. Sometimes that's good and sometimes that's bad. If, for example, the partnership has income that year and you need that to be offset by losses, that can be a benefit. That way you're balancing out and paying less tax. However, if you have income and no losses, that's paying more tax. And so you want to be mindful of where you are in your business and whether this is going to be the best choice for you. One more thing I want to point out when we talk about formalities. For a limited partnership, you're going to need to file a certificate with the state. So that's just a formality. You know, we talk about knowing what filings need to be done, what forms need to be filled out. And so when you start to talk about establishing these businesses in these structures, you think about consulting with an attorney. If you don't feel comfortable doing it on your own, you want to make sure that you do it properly so that your business stands. Okay, and finally, we have the limited liability company. Everybody's heard about an LLC. I don't know if everybody knows what it means, but we're going to talk about it today. A limited liability company is a mixture of your sole proprietorship and a C Corp. We're not going to talk about C Corps in detail today, but those are like your major corporations where there is complete separation between the individual and the entity. And you think about C Corps, you think about stockholders. And so for limited liability company, we're going to put those two together. The way that they come together, one is in the flexibility of governance. So the C Corp is run by a board of directors, and you got shareholders that have rights and have a say. With the limited liability company, you're going to be run by your operating agreement. And so you get to choose. You get to set the rules. You sit down. You can write it out. You can have one person and write out, excuse me, and write out exactly how you want your business to be run. You can also write out who will take over in the event that you die, in the event that you just want out, you want to retire, but you want your business to continue to live. You can talk about some of that succession planning in your operating agreement. When it comes to taxation, there's, again, flexibility. So remember when we talked about limited partnerships, we talked about pass-through taxation. A limited liability company can elect to be taxed as a partnership with the pass-through taxation or as a C corporation. And if you're taxed as a C corporation, it creates some tax, some separation between the individuals that own the company and the company as an entity as it pertains to tax. For liability, there is limited liability for an LLC, and that's why I believe most people look to this structure, especially when investing, especially when you're owning real estate. You want to protect your personal assets from the obligations and liabilities of the business. So that creates separation when it comes to lawsuits, when it comes to bills, creditors, all of that. Being in an LLC or investing through an LLC will create that legal separation. The disadvantage is that there is a thing called veil piercing. And this goes hand in hand with formalities and requirements. If you are not on top of your P's and Q's with formalities and requirements with an LLC, a court could choose to set aside your limited liability and pierce the veil and make you personally liable for the debts, obligations, liabilities of the business. And so limited liability companies are great. They help a lot of people protect their assets and protect their businesses. However, you want to make sure that you are on top of those formalities and requirements to make sure that you get the benefits of the business structure. Okay, go to the next slide.
So when we talk about thinking about legacy, we want to think about both the personal and the business side and making sure that we're using the proper tools to be able to set us up for success. And so when you think about your legacy, I want you to think of 5 steps, because 5 steps, you know, like the 5 heartbeats, like, you know, all that kind, it's just easy to think of 5. It's one hand, right? Just bat, 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 bat. Here we go. The number one thing is you want to learn the rules. And that's what we share with people. That's why we say that action begins with understanding. That's why learning the rules is the first step. So you've got the general rules around legacy related to personal and legacy related to business. And so now what we want you to do is you don't have to come to us, but we want you to engage an advisor. Because really when you think about properly planning your legacy, you want to make sure all bases are covered, right? You can't Google your way to legacy, unfortunately. You really do need to sit down with a professional who can say to you, here are the steps that you can take. And then you get to decide whether you use that particular professional, but you should sit down with one so they can help you to then create your vision. So you're going to come to them with some goals and you're going to say, hey, you know, I got a business. I want to make sure it goes beyond me. And then they're going to create a vision of what that actually looks like. Using estate planning and business succession tools, how can we now create the vision for this goal that you have? Remember I said you start with the end in mind. So where do you want to go? The advisor helps to get you there. The next thing you're going to do is you're going to actually write these rules down, right? So you're actually going to establish the business entity, or you're going to establish the personal estate plan, because you want to make sure now that your rules actually reflect what you want. And a lot of times when people see things on paper, then it becomes real. Then they become more comprehensive, more thoughtful, more intentional about the decisions that they're making. And so once you do that, then you have to execute. All right, because talk is cheap. Action is where it's at. So you have to make sure you execute. On the legal side, remember we talked about making it plain upon tablets. You got to write it down. It's got to be enforceable. When it comes to your legal entity for your business and what you want to do, Kristen mentioned that, you know, LLCs are ruled by the operating agreement, which means if there is someone in the business who becomes incapacitated, what does the operating agreement say is going to happen? Those are the kind of conversations that you can have with an advisor who will then make sure that your plan is executed, and so you know what to do next. So if you want to contact us to assist you with those things, we're happy to help you with that. If you made it all the way to the end of our presentation, if you got all the way through the video, we can't leave you without a gift, right? I mean, it's like you can't go to church and not eat right after. So you can't come to a presentation and not get a little gift for yourself. So if you want to contact us to help you, we are more than happy to help you. And if you reference that Z sent you, then you can get a free 30-minute consultation with one of the attorneys at the Griffin Firm, so we can help you to truly create your legacy. Remember, don't leave your money without some instructions.
Right.
Don't leave your business without some structure. Somebody quote me on that. I just made that up. Just somebody quote me on that.
I think we recorded. I'm gonna make a meme just for you.
So yeah, so if anybody has any questions,
Yeah, I've typed quite a few. Looks like I'm the only one that has the questions. But so I will start. My first question was, who is the trustee in the trust, or is it a designated attorney, or how does that work?
That's an excellent question. So the trustee, so this is the power of estate planning. You get to choose. You get to choose. The trustee is the person who you trust to manage the instructions that you've left in that trust vehicle. I know I've used the word trust a lot. So
Okay, that's okay.
You get to choose any adult that you know would do right by you and empower them to act as your trustee when you create your own estate plan.
So it doesn't have to be an
It does not have to be an attorney. It doesn't have to be family. It can be anybody that you choose that you know would do right by you.
I know that. Okay. All right. And my second question was, is a sole proprietorship, and I think you answered this as you went along, is a sole proprietorship and a single member LLC the same thing? And you answered that question.
That's a good question. I will point out though, because some people will see, you may see that a single member LLC is what's called a disregarded entity. You might see that when you're, if you're doing your Googles. The difference is that in an two things. One, the LLC has more requirements to formation, and then two, the LLC can elect to be taxed as a corporation. And in that case, there would be the separation between the owner and the entity for tax purposes. So that's important to remember.
Gotcha. Okay. So the third question is, so your firm would do the actual planning and structure of the business, not handling the actual taxes for the entities, correct?
That's correct. So one of the things that we actually try to do is something called a personal board of directors, because when you're thinking about people who do legacy, there's a number of different advisors that you can have related to that. So while we facilitate the actualization of your entity using legal documents, if you're talking about tax strategies, you want to talk to a tax advisor. If you're talking about buying more properties and making sure that you're paying attention to the market, you want to talk to a real estate advisor. And so we can all work together as your own personal board of directors to make sure that whatever decisions you're making, they're legally sound, they're structurally sound, it's going to maintain beyond your life. And also it's just going to be a prudent decision for you to make because you've got all the knowledge that you need. So yeah, we do the estate planning, we do business structure, business succession planning, and then we have partners that we can refer out so that you can make sure that your tax questions are answered, that your real estate questions are answered, all that good stuff.
Okay, I like it. I like it. Okay. We're getting some more questions coming in. That's good. All right. So how can you create a plan when many of us don't know what we don't know? And are we strictly going off of what the vision of a person is?
This is a great question. And this is why I tell people to use an advisor, right? Because the thing is that, again, you're going to come with your goals and you're going to say, this is what I want to do. And a good advisor is going to ask you about yourself, about your family, about your history, ask about your assets, because it is a facilitator of whatever you're trying to make. And then they're going to talk to you about, how does the law apply to my personal situation? And what are the options and the choices that I can make, right? So what we've given you is we've given you general information. What you now need is you need specific information. So that's why you want to sit down with a professional. It can be us, it can be somebody else, but also because you're sitting down individually with the professional, you're really going to have to kind of tell your business.
Mm-hmm.
So you want to make sure that you're sitting in a situation where confidentiality about the business you're about to share attaches, right? So you want to make sure that the creation of your plan really depends on all sorts of different factors that an advisor is going to be able to ask you about. So it's just like when you're creating a financial plan and you say, hey, I want to be able to retire with this much money. The financial advisor is going to go, okay, here are the options. You can do it through stock options. You can do it through real estate investment. You can do it through investing in all that kind of stuff. And so I'm obviously not a financial advisor. But, but the point is, right, is that you come with what you want to do. They look at what you have and they give you the path to get there.
Just working backwards.
Yeah.
From the end in mind.
Exactly.
So the next question is, how familiar are you with the difference between manager-managed and member-managed LLC? And do you work in multiple states? Want me to repeat that?
I got it.
Okay.
So good question. And it is as clear as the title. So manager-managed LLC, and there's sometimes it's not as clear as the title, so that's not always the case. But this time it actually is. Manager-managed LLC is going to be one that is managed by one or more people who create a management team, and the rest of the members. It's similar to the limited partnership. So in a manager-managed LLC, you have one or more people that manage the business, and the rest of the members are kind of passive investors. And in member-managed LLC, everyone has a say in the operations of the business. And so usually your smaller LLCs or a single member LLC, of course, is going to be member managed. And then when you have larger LLCs, if you have 100 people, they can't all have a say in the day-to-day operation. So you want to pick choose a group of people or one person to actually run the business. So that's the difference. And we do work in multiple states. DC, Maryland, and Virginia, and Massachusetts. Did I forget any?
And Massachusetts.
No. Mm-hmm.
DC, Maryland, Virginia, and Massachusetts. All right. I like it. All right. So next question is, what would trigger a veil piercing?
That's an important one. Okay. So we talked about formalities. And once you are more familiar with the formalities of an LLC or a corporation, you will understand better, what that looks like. Most commonly, or, to my understanding, my experience, it is something fraudulent. So there was a story about a man who bought out a coffee shop. It was a really popular one, maybe Pete's or something like that. He bought out the business, but he used the business to borrow money, and that he spent it on himself. And then he declared bankruptcy for the business, thinking that was just going to be cleared out because he had this, legal separation. No, that is an instance where the court would be like, no, you owe this money. We're coming after you.
Not right.
He tried it. He
really tried.
No, it's like America's dumbest criminals. But one way that you can fall into this without intending to is not having a clear separation between your personal finances and the business finances, especially when you are a single member LLC and you're like, oh, well, I'll just pay my bill from the business account, or I'll just use business credit card. And a lot of times you can sometimes you might not get caught, but sometimes you will. And so you don't want to get into those habits. You want to make sure that you keep everything, delineated and separate, just to avoid bill piercing altogether. Excellent question.
Wow. Okay. All right. So I think this is the last one. What is the difference between an LLC Subchapter S and an SCorp? Which is best for a real estate investor that has mostly passive income, such as buying holds or notes?
I mean, y'all are really coming for my education.
Like, these are educated questions. These are educated questions.
You hear me? That is a good question. Okay, so the difference between an LLC Subchapter S and an SCorp. So an SCorp is, so Subchapter S refers to Subchapter S of the Internal Revenue Code and which details how a business is going to be taxed. An SCorp, some of the things that distinguish it from other forms are there's a limit on how many stockholders there can be. I think it's 100, and that's the maximum. With an LLC, you can have an unlimited amount of members. An SCorp is also limited in that all of the stockholders have to be U.S. citizens. And so you can't have anyone who is not a citizen of the U.S. or a business that's not U.S. based as a shareholder. Whereas with an LLC, you could. In terms of what's best for a real estate investor, I feel like I would need to know more about the business and the plans, what your vision is, where you want to go in the future. Because we also think about, if you are on the verge of, major investment or major gains, you don't want to set up something that works for you now that you're going to have to shift later. And with each business entity, with each business structure, there's different rules when it comes to shifting. So, going from an LLC to an SCorp or an LLC to a corporation, sometimes it's easy and sometimes you have to dissolve the whole thing. So, there's a lot of the factors that will go into that decision.
Okay. I like it. Okay, so we have another one. So you guys have your offices in different states, but in your resources, are there any other advisors that maybe in your network that you could refer, like say in Georgia, someone is asking, maybe if you had a firm that you could recommend in Georgia, perhaps?
Yes, absolutely. So our founder,
give you a call.
Yeah, so you can always email us and we are happy to send you a referral that is out of state. If you are someone who we can't serve personally as one of our clients. Another thing to know about is our founder is also one of the founders for the Association of Black Estate Planning Professionals. And so if in particular you are looking for a Black estate planning professional, then look up ABEP, ABEPP, Association of Black Estate Planning Professionals, and they have a network of people who they can recommend, around the country, so you've got people in California, people in Texas, people in Georgia, people in Chicago. So, you got in New York, you got a couple of different options, but you can always reach out to us and we can always try to connect you with someone in a different state, wherever you are.
Thank you. All right, that looks like that was the last question. Oh my God, thank y'all so much. That information was awesome. I really appreciate you guys doing this for me. And so those of you that are on the actual Zoom, you can save the chat, and that information is going to be there for all others. Of course, you know, as always, I record it. So please go back and watch this very important webinar. This is probably one of the second best ones that I've had so far.
I see you're not trying to offend anybody's
had a really good one on taxes a couple months ago. That was really good too. But thank you, ladies, so very much. I appreciate you all for taking the time. And that's all we got.
Thank you.
Thank you for having us.
All right. Bye-bye.